So joining me now to explain what this actually means is Misty Marris, legal analyst and trial attorney. Misty, thank you so much for your time. I think this sounds surprising. What is actually happening with these phone surveys by the defense, and is this normally done in criminal cases?
Yeah, this is something that we really need to break down because it does sound a little confusing. So this is what's happening. The defense is challenging the venue of Kohberger's trial. They're saying that the county where these terrible deaths occurred is too biased for Kohberger to get a jury who will be fair and impartial. The population is only about 40,000 people. So what the defense did was hire a jury consultant. They're surveying, and when we say potential jurors, these jurors aren't impaneled. This is just members of the community who could ultimately end up on the jury. They're asking 9 questions relating to issues in the case and asking these potential community members who could be jurors whether or not they've heard of these issues and what their impressions are. Now, prosecutors said this is not right. There is a gag order. The defense cannot call anybody in the community and talk about the case. This issue then went to the judge to make a determination about whether or not this practice can proceed. And Nicole, to your question, it is not uncommon in areas where you have a small pool of jurors in order to get down to the bottom of whether or not the case may need to be transferred to another county. So this is all in furtherance of the defense's application to change a venue.
Okay, so Misty, what is the defense team actually doing with the information they are gathering?
They're gathering the information from these 9 questions that they're asking the jurors, and they're making a determination that will be actually set forth in a filing. They're going to say that the jurors in this area essentially know too much. Emotions run too high. There will not be the ability to actually get an impartial jury. And guess what, Nicole? They actually want to do this in other jurisdictions in the state to make the same arguments. So this all relates to that argument for change of venue. And interestingly enough, a lot of the questions that were at issue in the courtroom, the reason the judge made the determination that they can proceed is that everything in these questions is actually already in the public sphere. So the broader issue is that these types of cases where you have a high-profile case, it's very difficult to find individuals who haven't made who haven't had an impression about the case before you get to trial.
I want to talk more about that, but first I want to talk about some of that other information that's in the public domain at this point. Last week, we learned Kohberger's team plans to use cell phone tower data to show he was somewhere else when these murders happened. Do you think that's a smart strategy?
We always knew there was going to be a lot of forensic evidence in this case, and that the defense was going to go after what the prosecution put in their probable cause affidavit. So the prosecution has said that Kohberger's cell phone pings put him in the location of the house. We knew the defense was going to try and bring in an expert to contest that. What we didn't know is that the defense is going to try and say that he was miles and miles away using their own forensic experts. So certainly that's the strategy. If the defense has an expert who can testify on that point, that's a strategy to try and raise reasonable doubt as to Kohberger's location. Now, Nicole, his alibi that he's out looking at the stars, he's looking at the moon, I wouldn't call that an airtight alibi. Right. So, of course, we're going to need other types of information from a defense perspective that would tend to undercut the prosecution's case. And in this case, we're going to see a lot of experts.
So, Misty, we're talking alibis. We're talking defense strategy. There has been so much coverage of the case. The trial hasn't even started. We're still waiting on a date for that. Do you think this will impact the ability to seat a jury in this trial?
In high-profile cases, there's always going to be people in the jury pool who have heard of the case. In fact, it's impossible not to have heard of the case at this point in any jurisdiction across all of America. And so the fact that something is high-profile alone does not lead to a change of venue. It's up to the judge's discretion whether or not there's so much bias in this small community that another county would be tapped in to hold this trial. But that's not dispositive, Nicole. We see it all the time in high-profile cases. What generally happens is there's a more stringent voir dire process, jury questionnaires, and other fail-safes that help the lawyers ascertain whether or not, even if a juror has heard of the case and has heard of the evidence, can they be impartial and base their decision by what comes out in the courtroom.
All right, we will certainly see what happens. Misty, thank you as always.
Thank you.